Good morning, everyone, and welcome to the June 2025 Morning Blend. I'm Alison DiFlorio, and once again, I have my co-host, Lori Armstrong from Fox, joining us. Hello, Lori.
Hello, Alison. How are you today?
I'm well. We were both saying for anyone who is in the Philadelphia area, it's kind of a dreary day today, so it's perfect time to grab a cup of coffee and talk about some HR and legal updates. For those of you that have joined us before, you know that this is designed, it's a quarterly program that we've been doing for about 5 years now. And we never know until a couple of weeks before the webinar what we're going to be talking about, but we have some really interesting things to share with you today. And we wanted to do something a little bit different today as well. We wanted to add a category of what's your brew. So we are going to encourage anyone who has joined us to share your questions about any topic, HR, employment law related, and we will do our best to address that today. If we don't have enough time to get to all the questions, we can follow up with you separately or share information with you via email. But we thought that might give you a chance to address some of those burning questions that you have. Before we get into some formal introductions, I just want to share some standard housekeeping here. We are recording this session, and we will be sending the link out post-session. So if there's someone in your world that you think would benefit from hearing this information, please share that with them. Your phones or your computers are on mute, but your questions are really important to us. So we're going to ask you to use the chat feature. And again, we will address them toward the end of the program or as they come up as best as we can. And with that, I think I'd like to just go into a little bit of some formal introductions. I know many of the people joining us have been on a morning blend before, but for those of you who have not, I am the co-founder and managing partner of Exude Human Capital. We are a Philadelphia-based human capital consulting firm who does work in three areas: human resources outsourcing, either by project or an ongoing basis, equity and inclusion, and leadership development. We really look at HR as a combination of the three of those areas, that they all need to be aligned and be mutually supporting of one another in order to have a sound HR process. I hope to share with you today some of the insights that we are seeing with the organizations that we work with. We work with both the for-profit and nonprofit and government entities. So hope to share some lessons learned and best practices with you today. And I'll turn it over to Lori.
Well, good morning, everybody. I am a practicing labor and employment attorney. I've been doing it for, I get to say, almost 30 years now, I guess. And I spend part of my time dealing with traditional labor issues, part of my time doing employment litigation, discrimination, wage and hour, those sorts of claims, and a lot of my time I'm doing counseling advice and training. And in my spare time, I corrupt young legal minds at Temple Law School, which is something I really enjoy. And I'm also a um, volunteer mediator with the EEOC. So lots of fun stuff. And my students are always like, "You're so passionate about this." And it's because this area of law is constantly evolving. I know we're going to get into sort of our hot topics first. And I will tell you, as we were sitting here, across the wire comes that, believe it or not, conservative Senator Josh Hawley has plans announced that he's going to introduce legislation to raise the minimum wage to $15 an hour.
Oh, how
So
interesting. Okay.
yeah, so we'll talk about that more. But anyway, I'm always happy to be here with Alison and happy to help any of you. If you don't have regular labor and employment counsel and something should come up, please do feel free to reach out. I'm always happy to be able to help and to learn more about you and your organization.
Great. And I want to give a quick shout out to someone behind the scenes who's always here with us and making sure our technology works and that you get your invitations to these webinars. And that's Whitney Beasley, our marketing person. Thank you, Whitney, for all your help making sure these go off without a hitch. So
Yes.
with that, we have some Supreme Court updates Lori's going to share with you. And for those of you in this area, there's the New Jersey Pay Transparency Act. And if you're not in this area, this still may apply to you. So you have to listen carefully to what this act it talks about. We will do a legal update as part of our daily brew. We're going to talk a little bit about HR readiness in uncertain times. We've been getting a lot of questions about it's kind of an interesting time in the business world. And what should HR people be focused on right now? And then lastly is that section that I spoke about, which is what's your brew? So remember, please feel free to share your questions in the chat and we will get to those as best as we can. So without further ado, I'm going to turn it over to Lori to kick us off.
Piping hot. Ooh. So you all may remember in the last morning brew, we talked about, and I was pretty emphatic about this, that, there have been a lot of executive orders and guidance from the EEOC, sort of clarifying what Title VII says. And Title VII is the federal statute that prohibits discrimination on the basis of race, color, national origin, sex, and religion. And the statute has not changed. And notwithstanding who's ever in the White House, executive order, new EEOC commissioner, the statute says that you cannot discriminate on the basis of these protected classes. Now, that said, there have been some jurisdictions prior to this decision that came down on Thursday that sort of looked at what some people call, quote, reverse discrimination, um, with maybe a higher level of scrutiny. And, that I've always found that to be problematic because the statute doesn't say it only protects, by way of example, you know, Black Jewish women who are um,
Over the age
lesbians
of
and
40.
from, some part of the world, right? It's neutral. It just says we can't discriminate on the basis of race, whether that race be white, black, Asian, something else. And on Thursday, the Supreme Court, in a unanimous decision authored by Justice Jackson, who is seen as a liberal justice, held that no, the standard is the same. There's no requirement for this heightened scrutiny, where it's, what some people call reverse discrimination. The idea being that discrimination is discrimination,
Mhm.
whichever way we're talking about it. Um, and so that's sort of a big deal if you were in one of the federal jurisdictions or state jurisdictions that uses the federal law to analyze these claims, in that it in those jurisdictions that were doing it, frankly, the wrong way, they now have been told by the Supreme Court that's not how you do it. But what's also interesting about this case, and it hasn't gotten a lot of play, is this wasn't a race case or a standard gender case, i.e., woman didn't get the job, man did, didn't get the job, that kind of thing. It was a case based on sexual orientation discrimination. And you may recall that there was a case called Bostock that came down, I believe it's in 2019, in which Justice Gorsuch, for all the other labor and employment nerds out there who like this kind of stuff, also a conservative justice, had wrote for the court, and the court found that sexual orientation and gender identity are protected classes under Title VII because they are within the definition of sex. The reason I'm going to geek out for a minute, this is sort of interesting, is because typically conservative slash plain text justices don't interpret in that way. They will say, well, the word sexual orientation isn't in the statute. If that's what Congress wanted, that's what they would have written. And in this case, we had a conservative justice say no. So why do I bring that up? Is because all 9 justices agreed with the decision in this Ames versus Ohio case. And there was no question about whether sexual orientation was a protected class. And so what that means is, because we've seen, some executive orders or guidance from the EEOC that sort of seem to question the Bostock decision. And I would take from this decision, the Ames versus Ohio Department of Youth Services case, that sexual orientation is a protected class. Just by way of background, the plaintiff was a straight woman um, who had applied for various positions at she was already working there, but she'd applied for some promotions. Her supervisor was a gay man. The employment decision that led to her filing this particular lawsuit, she did not get the job, and a lesbian woman got the job. And so she contended that she was being discriminated against on the basis of her sexual orientation as a straight woman. Now, Supreme Court doesn't decide the ultimate issue as to whether or not there was discrimination, but the court didn't question whether a person could bring a claim based on sexual orientation, and in fact, seem to condone that you can based on Bostock, and that whether you're a gay or lesbian person suing for discrimination or you're a straight person suing for discrimination, the analysis is the same. And so this is sort of interesting. I would note that a lot of the challenges we're seeing from the current administration tend to be more centered around gender identity. So this may not be that surprising, but this is a kind of rare where we have a course that generally rules 6-3. They are unanimous on this issue.
Mhm. Really
Um,
interesting.
so Title VII says what it says, and it always has. So there we go.
There we go. Let's move to New Jersey pay transparency.
Yeah, so this is one of those super exciting laws that people get all, it's not nearly as sexy as some of the other areas of law that we're in. Um, but New Jersey, is typically one of the more progressive states in terms of legislation. It's like we call it like the younger stepchild of or sibling of California. And on June 1st, their latest pay equity law went into effect, and it requires that employers provide information regarding pay and benefits for postings of basically all types of opportunities. This is a little bit broader than maybe we've seen. You can see the language from the New Jersey Department of Labor website on that first slide. It applies to employers with 10 or more employees over 20 calendar weeks that do business, employ workers, or take applications for employment within New Jersey. So even if you don't have an office in New Jersey, this law
Mhm.
can apply to you. Now, it's a new law, so there may be questions later about whether that coverage is, um, enforceable if I, am in Pennsylvania and I only hire Pennsylvania workers and somebody's reading an ad that they're living, they're at the shore and they're reading it on the Indeed. But for right now, it covers if you're doing any kind of advertising and it's going to reach somebody in New Jersey, then this would apply to you. So the postings have to include various information. And by the way, those postings are also for transfer opportunities that are advertised both externally and internally. And you need to include either the hourly wage or the salary range. This isn't new. We've seen this in New York and in a lot of other
Right.
areas as well, but also a general description of benefits and other compensation programs for which the employee would be eligible. If it's a promotional opportunity, absent it being sort of we already picked somebody and they're developmentally being promoted, it also applies regarding these notice requirements. And there are penalties for noncompliance, $300 for the first violation, 500 for subsequent violations. And that it looks like violations are intended to be interpreted broadly. So not just it's not like a cost of doing business fine, like I posted it, but I didn't include this information, therefore it's only $300. Um, so we'll see. It's new, it's only what, 9 days old.
Yeah.
So but this is sort of consistent with trends we've seen around the country, kind of an effort to deal with pay equity issues. And I will tell you, when pay transparency laws first came out, and the prohibition on asking about previous salaries and things like that, I kind of balked. um I was like, that's capitalism, right? If I can hire you and it's cheaper as a business owner, why would I not want to do that? But I have come around to thinking that these aren't a bad idea because everybody knows what the deal is going in. And so, if I'm a job seeker and the compensation isn't in a range that I'm interested in, I'm not going to waste your time. And now employers are valuing jobs for the job. The focus is on what is the job value,
Right.
um, not that an individual's value isn't important, but it's less about the individual and what is the worth of the work that's being provided or the skills being provided for this particular role within the company. So I don't, you may have some comments, Allison, on this one.
No, I think I underscore everything that you said. I actually think this is a good thing for all of the reasons that you just mentioned. And I do just want to draw attention to everyone on the call, on the webinar, making sure your salary structures are in order is an important piece. We know that job seekers today are looking for transparency in pay practices. That does not mean that everybody is at a place where it is public knowledge what everyone in the organization makes. That's a level of transparency that we rarely see except in government, right? However, people do want to know how they can earn more money in that organization. So the ability to have a good sound pay structure, whether it's by grades or levels, or to Lori's point, what do I need to learn or develop or grow into to be able to earn more money here? That's something that job seekers are asking for. They want to know what their options are. And it's not necessarily, a ladder step. It could be more of a lattice step. How can I grow my skill set and develop so that I can earn more money? So I'm a fan of these pay transparency rules. I think, yes, do they require that you pay a little bit more attention to your job postings? Absolutely. But I do think, as Lori pointed out, it'll also weed out the people that are not in that salary range or that wage. They're looking for something outside of that. So, uh,
Yeah.
yeah,
Before we jump to the daily brew, I do want to make a comment about Senator Hawley's legislation because I mean this literally just came across the wire here.
sure.
So this is piping hot, right? If you think about it, I think the last time the minimum wage was raised was, hold on, I think it was in the 80s, but let me check.
I know it's been at least 3 decades.
Oh no, I'm wrong. It's 2009. It went from
Okay.
655 to 725 an hour. But if you sort of think about, what before 2007, it had been stuck at 515 for 10 years. But if you think about sort of the value, this is one of the criticisms that Senator Hawley raised, and it aligns him with a lot of folks in the Democratic Party, and that is that the value of 725 isn't what it was when we raised the minimum wage to 725. And I talk about this a lot when I'm doing multi-generational training and how to get along and all of that, the okay boomer sort of perspective. And it's like, what does 725 buy you? Like you'd have to work for an hour to buy a carton of eggs. And we don't tend to think of money in a relative form, but when you start to break it down that way, and part of Senator Hawley's proposal, which I have long agreed with, if we were going to set a minimum wage, is that it would be then tied um, to, I guess, cost of living increases. So the proposed statute is called the Higher Wages for American Workers Act, and it would raise the federal standard. Oh, I'm sorry, in 2026, but it would increase in subsequent years to match inflation, which I think is interesting because inflation goes up and down. Anyway, be
Yeah.
that as it may, I don't have any more information on it. We've certainly seen the 5 years ago there was a big fight for 15, and I think the mainstream and the conservative folks were like, that's a terrible idea. And now it's maybe gotten some traction. There is some recognition that we have pretty significant income disparity, and how do we fix that? And so stay tuned. but this would be a change to the Fair Labor Standards Act. And by the
It,
way, it still puts parts of the country behind state or local ordinances, um, who have been at $15 for some period of time now. But
yeah, and I think was it California that just said that they're looking to raise it to 20, or they already did, or one of the states just talked about raising it to $20 an hour, but interesting. It is curious that they say that it would be adjusted based on inflation. I
if I were
want to
going to
read
guess, that part's not going to,
yeah, that I
that's
don't
not
think
going to
that's going to,
go.
yeah, I
But
don't think so. Uh,
um, yeah,
great.
I think the district in the DC has the highest minimum wage, I think, at 1750. Um, and then
Yeah.
Washington State is pretty close behind. And I had not heard um, about,
It hasn't passed. I'm pretty sure it's California though is talking about it, so I don't
yeah,
know if
yeah.
that's going to happen.
Anyway,
Okay, well, let's move on to the Daily Brew. Just a reminder to everybody, we're going to do a couple of quick updates, and then please feel free to share your questions in the chat, and we'll do our best to get to those. So, Lori, what else is going on in the legal world?
um, yeah, oh, somebody posted in the chat. There are cities with even higher than the state minimum wages that I referenced. I think SeaTac is among the highest at 20 something. So, okay, what else is going on in the world? So, there was a lot of sort of consternation after one of President Trump's executive orders, sort of, and the rulings on affirmative action and so forth. And what do we do about our EEO-1? Well, um, we're still filing them. So the portal opened on May 10th, and you only have until June 24th to submit your data. So if you're an EEO-1 reporter and you know how this works, fabulous. If this is new to you, call me. It's actually not my area, but I can refer you to somebody who can certainly help you with this filing requirements. For those of you who aren't familiar, which I would imagine all of you are, but in case you're not, it was intended to be a way, for the government to sort of track information. It was never intended, and the guidance that came out with the opening of the portal was never intended to be a way to for employers to rely on sort of quotas or racial um, um, mandates or things like that. And so again, that's not a change, but we're really that's being emphasized so that employers are doing it the way they're supposed to and not using it in violation of any of the executive orders. Um, the Department of Labor, for those of you who've been around for a while, used to issue these things called opinion letters. And it was basically, you or your lawyer would write a letter to the Department of Labor, whether it be OSHA or the Wage and Hour Division, or one of the other divisions, and say, sort of hypothetically, if we were paying people this way, would that comply with the FLSA or be a violation? And then the Department of Labor would issue an opinion letter with a whole bunch of disclaimers in the first two paragraphs saying, we're not giving legal advice and we can't tell you for sure, but generally speaking, based on what you've said, the reg or the law would be interpreted in this way. And while they weren't law, it wasn't the same as a judicial opinion, it was helpful guidance and certainly useful in an employment litigation case as a basis for a good faith defense. That even if it turned out that the employer didn't comply with the law, they could say, well, we thought we were because we have this opinion letter. We sought advice from the agency. The agency said, essentially, you should be okay, or we're not telling you that you're wrong in any event. And so I think for a long time, people appreciated this access, if you will, to the government. And then the government stopped issuing them for, I can't even remember now, a while. Um, and so, I mean, I sort of like the fact that they're relaunching these opinion letters. Some people probably don't agree. What's kind of interesting about it is this is after um, the Supreme Court decision that I've talked to you all about, the Loper Bright decision, which basically undermines shortcut, layman's version, undermines the authority of federal agencies and says that the courts are the ones that are really the interpreters of the law and whether or not they're constitutional. So this doesn't kind of square with that, but good to know. So if you're changing a pay practice, if you have, some sort of OSHA compliance question, trying to think of there's 4 areas. Give me a second. Um, and you want some guidance, or you want to at least have some um, something to rely on, you can use the opinion letters. The other 2 areas, actually, there's 3 areas. I just never think of the fourth. The Employee Benefits Security Administration, the Veterans Employment and Training Service, and then the last is Mine Safety and Health Administration. So those are there are actually 5 divisions within the Department of Labor that will be issuing these letters. Okay. Executive order issued on April 23rd. It's kind of consistent with the other executive orders that we've seen. This one is called Restoring Equality of Opportunity and Meritocracy. It is a challenge, attack. I don't want to use incendiary language, but it is I think it's fair to say it's an attack on disparate impact liability. Disparate impact practices are things that, on their face, are neutrally valid, but have a disproportionate impact on people of a protected class. So, one of the earliest cases that came out is the Griggs versus Duke Power Supply. This was a 1971 case. And in that case, the Supreme Court held that employment practices, even if seemingly neutral, could be discriminatory if they have a disproportionately negative impact on a protected group, even without intentional discrimination. So, for example, in that case, the power company unilaterally implemented a requirement that people need a high school degree where that hadn't been a requirement for certain jobs. And that new requirement disparately impacted Black workers so that they were now kind of stuck, either not being able to be employed or stuck in lower paying jobs. And the analysis, without getting into all of it, is whether or not the neutrally, on its face, neutral policy, not only does it have a disparate impact, but then can the employer sort of justify the policy for for business necessity? And is there any other way of accomplishing whatever the business's goal is that would not disparately impact the people of the protected class? And so this executive order really is challenging whether disparate impact um, is lawful. And again, we're in this weird separation of powers thing about whether or not it's appropriate for the executive branch to be challenging something that arguably was created by the legislative branch and has been upheld by the judiciary, but it's out there. So, no guidance on what you should do. I mean, if I were an employer and I was, unfortunately, and I've had a lot of calls on these lately, if I was dealing, for example, with a RIF,
Right.
or some other thing that might disparately impact a certain class of people, I would want to make sure that I had legitimate reasons for the decisions that I was making. So I don't think that's changed, but I did want to bring it to your attention because it's out there.
Yeah, I was thinking the same thing with regards to RIFs, just to stay the course and do your due diligence the way that you normally would to make sure that you're compliant with how things stand currently from a legal perspective.
Yeah, and then usually for employment litigators, this is sort of like, and labor lawyers, I guess, June is sort of it's like our Super Bowl month or playoffs month because the Supreme Court comes out with all of these decisions. I just talked about the Ames case. And just by way of fun fact, I'm kind of nerdy, but my younger daughter was born on June 27th, 1998, which, for those of you who are playing along at home, is the day after the Farragher and Ellerth decision came out, which was the big Supreme Court case on sexual harassment and defenses to sexual harassment. And so, we're usually kind of like, oh, it's June. And I'll always remember that date because I went into labor and all of that. But anyway, We don't have that many employment cases on the docket this year. I would expect that we're going to have more given everything that's going on in the administration next year. But for now, we've already talked about the Ames case. That was the big one. The Trump versus Casa case is actually not really an employment case. It's the one challenging birthright citizenship, but where legal scholars are really focused on the impact is on the impact of national injunctions. You've heard me talk before. Certainly last summer we were talking about it. We were talking about, for example, the FTC's rule during the Biden administration that was going to invalidate restrictive covenants, non-competes. We talked about it in the context of the Department of Labor's adjustments to the white collar exemption salary thresholds. You may recall those conversations. And then someone will challenge it in court. And at some point, a judge will issue an injunction. And sometimes those are national or nationwide injunctions. And so as you may recall, I was like, ding dong, the rule is dead because there was a nationwide injunction. Well, this case, in part, has issues around whether or not nationwide injunctions are appropriate, enforceable, et cetera. So, this will come out before the end of June. And, we're going to have to wait and see. And the reason it matters to labor and employment folks is it is not uncommon for one of the agencies to issue rules and for those rules to be challenged and have, in particular, the Fifth Circuit is pretty well known for issuing these injunctions. So stay tuned.
Great. Looking forward to it. As we move along here, let me just double check and see, or Lori, you want to take a peek and see if there are any questions
Yeah, let me look.
group as we move to our HR focus for today.
Nope, nothing in the chat yet.
Good. Remember, everybody, this is your opportunity to ask anything that you'd like to. So I want to talk a little bit, we're getting these questions from our employers, given the uncertainty of business conditions. And I say business conditions, I mean, the economy is going through some uncertainty. So whether you're a nonprofit organization who is looking at, hey, are we going to have funding? Are we not going to have funding? There's a little bit of limbo right now, and that's creating uncertainty in the workplace. If you're a for-profit organization, you might be impacted by tariffs or wondering if you're going to be impacted by tariffs. So again, there's that uncertainty, which some HR people are feeling a little bit stuck. It's like a wait and see. What do I do? Now, you've heard from Lori that the laws haven't changed yet, so you continue to focus on that. But we want to talk about what you can do to support people who are also feeling a little bit anxious, your processes, and be able to improve reporting capability should you be asked to produce data to support funding or to support whatever audits or whatever you may need to do. So we thought it'd be helpful to spend a little bit of time just talking about what you can do now. As we have said many times before, in times of uncertainty, and I mean that those examples that I gave you, if there's word on the street that you may not receive funding for a particular program or it may not be renewed, without addressing kind of where you are, that can create a whole communication spiral. So we encourage you to communicate openly and regularly, even if you don't have all the answers. If information is not available, what's helpful is to communicate in the manner of here's what we know about XYZ, here's what we don't know, and here is when we anticipate learning more and we commit to following up with you at that point. That's how leaders, HR professionals can foster some transparency and reduce a bit of the anxiety that people have of kind of the fear of the unknown, right? So the more you can do that and encourage your managers to do that, it may be uncomfortable for managers who aren't used to having to communicate in times of uncertainty. So giving them some guidance in developing them, equipping them with the right tools to do their job. I am, not an advocate of scripting things, but I am an advocate of giving talking points to managers when they have to communicate change or in times of uncertainty. So it gives some confidence to a manager on what they can say with confidence. Sometimes we just say, executive level may communicate to managers saying, this is what's happening, and assume that everybody is comfortable having those conversations with the rest of their teams. That's really not the case always. So make sure you're giving them with the right tools, the right information, and those talking points for consistency and guidance.
If you don't mind,
Yeah,
Alison,
sure.
I always use this example, and it's really kind of the clear one. If you've ever been sitting on a tarmac, like on a plane, and you're delayed, even if the pilot comes on simply to say, I'm not sure what the holdup is, I'll get back to you as soon as I have some information, you feel so much better than
Mhm.
having zero information. So
Mhm.
I really take your point, even if it's we don't really know yet, but we'll, keep you apprised as we get that information. Super important and makes a big difference, I think, for your folks.
Yeah, and I'll add to that analogy. You've also been sitting on the tarmac when you can't really understand what it is that the pilot said because it's so garbled. If your managers aren't clear and consistent,
Yeah.
then, someone's going to go to Lori and hear one thing, someone's going to come to me and hear something else, and they're going to leave with just more anxiety and uncertainty. So the more you can make people comfortable and clear with things that are uncomfortable or unknown, the better. Uh, that said, encouraging feedback and dialogue from employees is also really important. Again, that's another area where knowing that your managers are comfortable and confident in asking for and receiving feedback, even if they don't have the answers to everything. That's an important skill for them to develop. It's in times like this, very important for employees to be heard and valued. I had shared on a previous webinar, I'm not sure if it was the Morning Blend or another one, about the levels of burnout that have been reported. There was a study done by a group called Census-Wide Research Group earlier this year, I think sometime in February. It was released, and they're talking about the levels of burnout, which is pretty astounding right now. They're reporting that 66% of the US workforce is reporting some level of burnout, with the age group 18 to 34s having levels in the 80s, like 83 to 87% of burnout. And I say that because this final bullet point here is talking about the importance of focusing on mental health support, whether you have employee resource groups or other resources that are available, wellness programs, flexible work options to help employees navigate some stressful situations. Interestingly, the group of 55 and up, they're experiencing burnout, but at about 49%, 50% of the are reporting that. Pay attention. For those of you that do have hybrid work environments, make sure you are jumping on camera to have conversations with those that may not be on site, so that you really get to read some body language, perhaps see how people are doing, and encourage your managers to do same. Lori, I don't know if you want to add anything there.
No, I mean, as usual, you and I are aligned on these topics.
Yeah. As far as your processes go, this is a great time to really reflect and ensure that HR is aligned to business goals and business strategies. Things may be changing, and you want to make sure that you are adjusting wherever your focus is in order to support the business. So stay closely connected to leadership. This is the time to have a seat at the table or have your voice be heard, and to offer insights to leadership about how you can support the evolving business needs to make sure that things are moving in the right direction and you're hitting your goals and objectives. As far as documentation, we've talked about in the past, make sure things are recorded well. I will tell you that in the work that we do, we still see a lot of missed opportunities in organizations to maintain updated documentation. Think about I-9s, think about other hiring information that you may be asked to report on at some point in the future. So go back, make sure your processes are documented. This is another thing. We find in the work that we do that sometimes the processes or the practices, the procedures live in someone's head and not really somewhere where if that person were to leave, that it is well documented. So if you have any of those kinds of processes or procedures in your area, make sure that those are well documented so that there's consistency and compliance. Again, make sure employee data is updated. We do a lot of work with HRIS systems. We do see data that has been put into them that is not clean. So as much as it's a not fun, tedious task, getting in there to make sure that the data that you are recording is good, clean data and accurately reflects your workplace, that it is kept restored or stored effectively for reporting purposes and compliance purposes. And again, in case we don't say it enough, educate and support your managers, equip them with guidelines. Those middle managers are really feeling pressure right now, particularly in times of uncertainty where positions that open may not be filled right away just because people are waiting to see if they're going to be able to support those positions. Managers then have to take the heat for perhaps other workloads being expanded and creating some stress from an employee level. And yet they also have to carry out the operations and operationalize strategy. So make sure you're giving them the gift of support and the gift of education so that they can operationalize your strategy consistently across their teams.
I cannot, we talk about this all the time. I have a client who just settled a litigation, and their managers were not as familiar with the FMLA as they should have been. And it created an opportunity for risk that required them to be in a position where they had to settle something that they otherwise wouldn't have. A 2 hour training session, 2 hours, is well worth your time and money to have people get sort of the legal boot camp and then some skills on effective leadership communication. And it's kind of a pain to schedule. I understand, because you have people and you got to pull them together and take them off of whatever they're doing, but so worth it for you and for them, because then they will feel like you're invested in them and their success. So I'm just gonna again sort of cheerlead for, training supervisors and managers. We often take like the best widget maker and we say, well, you're a great widget maker. We're gonna make you head of all the widget makers. You can be chief widget maker, but we don't, those skills are different. And so it's really, really important that when I do training, I talk about the they, us, they, and you'll hear employees say, well, they didn't treat me right, or they didn't give me time off, or they, whatever. And I ask, who's they? And then, people are like, oh, that they is us. And so, I do training. I know Allison's team does training if it's something you're interested in. Allison and I have done training together. So, I'd really encourage that, at least give them a couple of hours of, sort of HR boot camp, make it interactive, do it live. I think it's well worth your time. And one other thing, there, only because you were talking about data management, there was a question in the chat regarding the 2024 EEO5 data. That collection has been delayed, and currently on the EEO website, it says updates will be posted as soon as they become available. So we don't have any updates on the EEO5 from 2024 yet.
So stand by on that one. I want to
Yes.
add one more thing too about training. Yes, there's formal training, and as Lori mentioned, we would love to talk to you about that. There's also an opportunity to give sound bites of training at your monthly managers meetings, at your weekly leadership meeting. Take 10 minutes of that meeting and dedicate it to something that's going to help managers become clear on anything. So you just, because if you do let's say the FMLA training, it's not set it and forget it. It's not do it once. Have that information stored somewhere so people can recall it, because maybe a few months before they have to actually apply that. So make sure that you're creating that culture of learning and have a place where people can go and pull up information, or a resource to go to get that information to be, um, have the in the moment information that they need.
Yep.
So that brings us to the participant interaction here, everybody. So we are looking for your questions. Remember, you're not bound to asking questions just on what we have covered today. We really do want to make sure that we're giving you an opportunity to ask whatever question we may be able to provide some insight on or be able to, talk about offline. So we'll just give it a minute here to see if there are any questions.
Yeah, we don't serve coffee in the summer, so you probably won't get to chat with us again till September. So if you have burning questions, or even things that you just would like to hear us wax poetically on, we're happy to, give our thoughts on anything L&E or HR.
I will say, as an HR professional, and Lori, I'm sure you can, like, in your world, everything is evolving every day. In our world, it is too. But these are somewhat uncertain times, so it can be a little bit curious as to what can I do, what should I do, what should I focus on. So I want everyone on this call to know that you can reach out to Lori or myself anytime. We'd be happy to have a conversation with you offline, even if it's just to be a thought partner to talk through a particular issue. We're here
So
to
we
do
have a couple of questions in the chat.
it.
So one is regarding thoughts on recent ICE raids, um, which I know is getting a lot of press. So I've been speaking with our immigration partners here at Fox, and it's kind of interesting. So they wouldn't use the term raid. This is one of those technical things. I'm trying to figure out how. So I guess the thing is that I have some clients who have come up with policies regarding how they're going to handle if they get a knock on the door. I have some clients who have done internal audits to make sure they're complying with Form I-9 and the Immigration Reform and Control Act and other such things. Currently, to the extent there are raids, they are targeted to specific industries and or where they are getting intelligence that there are, undocumented workers. So my partners would say that you're if you're not in one of those areas, you probably don't need to be super concerned about that happening. If anybody has specific questions, I can't really give you advice on that in this context. If you want to give me a call, I can connect you with someone and you can get some information. Um, and then if you decide you actually need representation, you can use somebody in my firm or I can refer you to, I've lots of immigration lawyers around. But it really is going to be dependent on currently what industry you're in and or whether or not there's some reason to believe that you have a population of undocumented workers. Um,
I want to add something that we have seen for some of our organizations that have a client base that may include undocumented workers. So, what we are seeing employers do in that case is to educate staff on what to do if ICE does come in. And I'm not going to, it's a very individualized kind of response because it has to be what the organization is planning to do. But I think the point is employees need to be educated on who to refer ICE to if something were to happen, if they came to your organization. So I just think that that's important to note.
there's kind of a specific question on handling FMLA where you were about to terminate somebody and they make a request. Um, I'll give you general information on the FMLA. Not that I'm trying to equivocate, but I don't want to. I'm not ethically allowed to give sort of specific legal advice. So there's the disclaimer that you see in the front of the Department of Labor opinions. If you have a specific question you want to call me separately, that's totally fine. But generally speaking, the FMLA protects people who are taking leave for the reasons under the statute but that doesn't protect them from decisions that had already been made that were made for legitimate business decisions. So, for example, if you were in the midst of a layoff and that person's already on the list, the fact that they request leave doesn't change their status as being on the list. There are risks associated with any decision that you make. You should talk to your regular counsel before you proceed. Um, or you can call me if you don't have regular counsel. But the FMLA isn't, it's not a prophylactic in the sense that you get kind of super special treatment that other folks wouldn't be entitled to. I want to come back to the question on HR intern, maybe close with that because I think it's a great question.
Yeah, let me just
Um,
add a little bit on the FMLA though, also
yeah,
just to underscore that this just, documenting performance as performance issues arise is also one of the things that you can do in this particular case. Again, there's risk associated with it, but the better documented if you've been having performance issues prior to somebody going out, then that may be helpful to a case if termination does come into play. Go ahead,
you
talk
know,
about your.
ultimately, the question is that you have to answer as an employer is why did you make this decision?
Right.
And can you demonstrate that what you're saying is the truth? And
Mhm,
so to your point, Alison, if you don't have documentation and the timing looks bad,
mhm.
people are going to be more inclined to think that your decision wasn't for the reasons you're saying it. It's like, well, if they were a bad performer, why now all of a sudden? Now the only thing that's changed is they've asked for leave. So, it's a little bit nuanced. I agree.
And when they look at that last performance review and it's got, 5 ratings across and this person's great and great, and then there's nothing else in between that and them asking to go on leave,
Yeah.
then that could be problematic for you. So,
Yes. On the New Jersey pay transparency, there's a question about a specific succession plan. The way I read the regs is if it's kind of a foregone conclusion, something that's not getting posted, that the Transparency Act does not apply. But if there's going to be any sort of advertising or posting, then the notice requirements apply. But I'm happy to look into that a little more and connect um, to confirm, my understanding. Um, let's see, there's questions on how to provide support to employees who are nervous about immigration issues. Um, Again, this is sort of nuanced. Part of it is communication. As I said, and Allison talked about communication earlier. I have a client who has gone out of their way to specifically um, have a policy that says this is what we're doing, this is what the law says, this is what would happen in the event. And again, I think sometimes providing that information gives people some calmness. Happy to talk more about it, Allison. I don't know if you have any thoughts. Also happy to connect anybody with, one of my immigration colleagues, whether at Fox or somewhere else, to kind of give you more detailed information, because I think some of what we're seeing in the news is, when I say sensationalized, I don't mean that it's not happening, but we see it, and I'm not sure it's uh, if it's on the news, we think it's happening all the time, and maybe it's not as widespread as we're
right.
left to believe.
Right. I agree with everything you just said. I think you know providing some information and resources and direction, but it's depending on your specific ask, it might be helpful to speak to Lori or your lawyer, immigration lawyer on that.
Um, so I guess we only have a couple minutes. Maybe we'll end. I'd love this question. What advice would you give an HR intern who's just gotten into her field? Um, Allison, you
Wow,
want to take that first?
are you getting into it at an interesting time for sure?
Yeah. As Allison knows, my older daughter is an HR professional and graduated in 20, I can't remember, it was 18 or 19 from college. So she's been out for a bit, but this would have been a question she would have asked. So Allison, you want to give your thoughts first?
Well, I think it's important to get a taste of the different areas of HR, because sometimes you go full force into one area. Maybe you get into it dabbling in recruiting or dabbling in benefits, but take opportunities to expose yourself to all of the different functional areas of HR, and then determine which areas you want to go deep in, right? So think about benefits and compensation. Sometimes people say, "Oh, those are kind of boring," but actually they're fascinating and they're constantly evolving. And as you heard with some of the pay transparency laws and things that are not new, but they're evolving, having that expertise is important. Employee relations. Sometimes people shy away from that, but that's a fascinating area. And when we're dealing with times where there's high levels of anxiety, getting exposure to what the issues that you may have to help mitigate within an organization to reduce employee conflict or manage employee relations can be really helpful. So my advice is to take roles that are going to give you exposure to all of these different areas so that you can prepare yourself to either be a strong generalist, to lead
James
an
versus
HR
Ohio
function.
Department of Youth Services.
Sorry, guys. Not sure what
Docket
happened.
no.
Hold on.
Off below.
I don't know how to turn that off.
Argument.
Wait a minute. Sorry.
That's
Where's the
Opinion.
volume? There we go.
AI
Vote.
infiltrating that's the
Author.
first.
I'm gonna throw my
So,
laptop out. All right.
but that's my
So
advice. Lori, you want to add anything?
I would have said exactly the same thing. I also would say, do not be afraid of what I call informational interviews, right? Like, I know for me, if I have an associate or a law student or somebody say, do you have 10 or 15 minutes? I'd like to pick your brain on something. I'm always very happy to do that. All the folks that I know, all my clients are like that. Um, you want to be respectful of their time, but not only within, if you're working at a company, certainly cultivate some relationships with the folks in your company, but, join SHRM or attend events and, grab coffee with somebody and just have a conversation because they'll be able to give you some insight on, um, again, different areas within the field that you might have interest in. They might have tips that it wouldn't occur, to somebody that's not in HR. I think that getting to know people without an agenda is really important. I mean, other than, I'd like to get to know you and I'd like to learn more about, what you do or what your experience has been in HR. And I think most people are very happy to be able to share that and would be, happy to try to, bring you along in that regard. And sometimes you find a mentor, which is great,
Mhm.
in that way. So.
Great. Well, that brings us to the close of today's program, and we just want to thank everybody again for taking your morning to join us and hear a little bit about what we see going on in the HR and legal world. On behalf of Lori and myself, we just want to thank you for being a participant on the Morning Blend, and we will see you again probably in September. I think that's the date that we're targeting for our next episode.
See you in September. I'm not a
Yes,
good
and it's
singer.
going to the musical rendition will be the fall.
I'm only good at karaoke if everybody's had a lot to drink.
Great.
All right,
Lori,
all.
thank you again for your partnership, and thank you, everybody. We look forward to seeing you in the fall.
Thank you. Thanks, everybody. Happy summer.
Bye.